Do we have Mr. Rubai? There we go.
I clicked the wrong button. I'm sorry.
That's all right.
Mhm.
Mr. Rubai, you are here for the appellants. Do you wish to reserve 5 minutes?
Yes, Your Honor. Thank you very much.
You got it.
Okay, this is an appeal of a motion to dissolve a ex parte TRO that was entered by the court. Specifically, the ex parte TRO was filed with a verified complaint for injunctive relief, and it was filed on 12/17 of 22, right before Christmas, and there was an emergency ex parte motion filed 12/19 2022, and then an order entered by the judge granting that with specific findings on 12/20/22. From my take, if you look at the verified complaint and you look at the ex parte emergency motion, the entire relief sought in the complaint was granted in the ex parte injunction without a hearing.
Didn't you appeal that already?
Yes, Monia Rahal appealed that.
Okay.
The ex parte ruling, it was limited to just the pleadings as set forth.
Right.
But
there's been more water under the bridge, and now you all had an evidentiary hearing.
we filed a motion.
Court gave you a couple hours.
We had a motion to dissolve that was argued. I asked the court for 3 hours or 2 hours from my side of the case. The judge then said 2 hours, but then said one for you, and one for the other person. And then I responded, I thought it was just you asking me, and she did ask me what did I thought I needed. I never represented to the court, nor would I, that I thought a case as complicated as this could become made from only 1 hour side, especially since it was going to needed to be rebuttal on these issues. But anyway, be it as it may, the ex parte motion that was sought and granted, and which was later affirmed in its entirety, even though the oral findings do not really make the findings necessary. The hearing was on 10/2 of 24, which is the evidentiary hearing, and the oral pronouncements by Judge Alvarez was 11/21 of 24. In the meantime, I had filed a motion right after that on the 6th saying we needed more time and specifically spelling out what we needed to, because my client never got a chance to rebut or even call the witnesses rebutting what they were presenting in their case, which was that hour. And I
But the evidentiary hearing, you called the other side as an adverse instead of calling your client first.
Well, that's true. But the way I understood
you took all your time.
Yeah, I did take more of my time than I should have. You're correct on that, Judge.
Took all of it, didn't it?
No, all but 10 minutes. All but 10 minutes. And, yeah, I did make a mistake in that regard. I would agree. Although in the past, when I've had motions dissolved hearing, especially involving $17 to $20 million worth of property and complications like this, and not only that, Your Honor, my client only got to testify for 10 minutes, but more importantly, the other witnesses I had didn't get to testify, and the court completely misunderstood the status quo of the situation at the time the injunction was sought. Because on the only time that possession of these properties changed was on 12/20 when that order was entered. Because before that, for years, the trusts who owned the property were the owners of the property and managing those properties. And one of the concerning things about this case, and I only have a limited amount of time at oral argument, so I want to address some things that I think are like, I don't want to use the word no-brainers, but obvious. Daniel Feynman is listed as 18 properties. He never testified. He never swore to the complaint. He never appeared at the 10/2 hearing. Yet there's an injunction in his favor. On paragraphs 21 and 22, there were three evictions, paragraphs 21, 22, and 23. I should know them by heart. There were 3 evictions cited that had been filed by another party. Based on those, they asked for an injunction, and in the first part of the order, it says not interfere with the tenants, not communicate with tenants, not file evictions. Actually, all that we were fine with because my client never filed anything as far as that goes. But then on the order to the judge, it says that the plaintiffs are prohibited, the defendants are prohibited from prosecuting or defending any action involving the 25, involving the portfolio properties, regardless of whose name they're in. So, first of all, it was an injunction violates Logan versus Logan. It shouldn't have been entered. It was drafted in fairness, what was done to Judge Arkin, and she evidently went through the roof when she found this out. They did not tell her this whole entire matter was being litigated in bankruptcy court because they rushed down in bankruptcy court. The trusts were litigating because the trust had never signed a settlement agreement with the trustee and had never stipulated for their properties to go over to the bankruptcy estate.
Well, I took a look at what was put before us from the bankruptcy proceedings.
It's all
seems,
rushed.
huh?
It's all rushed.
Well, maybe, but it seems like on the substantive merits about whether or not there was a settlement that was reached about an allegedly fraudulent transfer before the filing of the Chapter 7, it seems like bankruptcy Judge McEwen had thoughts on that and issued a ruling and was pretty clear on that. And
well,
who all took issue with that before the district court, and Judge Mizell had pretty similar thoughts as what bankruptcy Judge McEwen had. So
it's before the 11th Circuit, Your Honor, right now.
Okay, all right.
The issue was before the 11th Circuit and being decided. But the important issue on this, Judge, is this. On 11/9, 11/17, Mr. Rahal went over to bankruptcy court because they had been mediating for 18 months. And he filed motions to get relief as he understood everything had to be handled in bankruptcy court. He filed motions there. They filed motions to strike that, saying it's between the trust and not him, and he can't bring this. At the same time, though, it's set for hearing for January 9th. They rushed down to state court and swear and get this injunction now claiming without joining the trust that what they asserted is that Monir Rahal and Middletown don't own the properties. That's true. They're in the name of the trust. They deliberately did in this court, and then they said we had a management agreement. Well, they knew on April 7th when they did this closing with the trustee, which was separate from my client, that they never had any estoppel letters or agreements to take possession of these properties. He was not agreeing at all with their position.
His lawyers were given notice.
Oh, no, what do you mean?
Wasn't Buddy Ford given notice?
No, none of this.
I see.
See this? What they did was very clever. What they did was this. They didn't have possessions of properties. They had these wild deeds that they had gotten from the trustee, which Old Republic wouldn't insure wild deeds anyway, so they had no insurance, and that was admitted on the witness stand. So what they did was, in order to get possession, they came to this court, to Judge Tesharkin, and made the specific allegation that Monir was there and Middleton was their management. And as a result of that, they could seize control of the properties and take the rents without revealing to the court the dispute over ownership and without bringing a quiet title action or an ejection action or anything else. Because if they had, Judge Arkin would have never entered this ex parte order. She said, you got to set this for hearing. You guys are fighting about a dispute. It's also in bankruptcy court. They're going to get a hearing. So as it was, they didn't get a hearing because they concealed the ongoing litigation in bankruptcy court. And regardless of where that ends up in the 11th Circuit, that's not the point here. The point is that there was no showing of irreparable harm to enter this injunction and to enter one stopping my client from even defending his actions or even prosecuting the actions, to strip his entire First Amendment rights and court rights. Now he's being in contempt even for appealing to the Second District Court of Appeal. That order should have never, at the 10/2/24 hearing, no evidence was presented at all as to the following things. First, nothing by the trustee, Daniel Feynman. Second, nothing for a litigation injunction. Third, nothing about prosecuting or defending. Nothing about security deposits. Nothing about accountings. Nothing about all the other things that were in this complaint. How did that get granted and why wasn't it dissolved on 10/2? If you look at Judge Alvarez's findings, she doesn't make any findings about those. They presented no evidence, and their oral argument and their written arguments didn't even say anything about it. Why are those still in the injunction? And why is my client facing contempt allegations for those things? And now we got other judges to see this. They go, well, this only applied to tenant evictions. It didn't apply to everything. But they wrote the injunction broadly in that one section so they could take it and use it against him and prevent him from defending himself or from even bringing up the merits of any cases that he has or any position that he has. And they did it at the 10-2 hearing. You look at the judge's pronouncements. There's no way she found injunctive relief on those other issues. I agree she reinstated the injunction, but there were no findings made whatsoever on the 4 required elements for all those other injunctions. And I presented cases that showed you cannot get an ex parte injunction on an oral contract, especially when it's disputed like this. No one even knew what the terms of the oral contract was. Rand comes in and says, oh, my reputation's been wrecked. Being wrecked by what? Taking $20 million of property for $4 million and not paying the owners anything? No, his reputation wasn't being wrecked, but no matter what, that's not an injunction. None of this stuff was a TRO, an ex parte TRO. In fact, they amended their complaint to bring all kinds of damages lawsuits afterwards. So what happened was, now we have a situation where all of these properties are in their possession. The bond wasn't even set anywhere near the value, so there's only $5,000. Never had evidentiary hearing on that. So no matter how much my client loses off of the deal, he loses everything. There's no potential remedy. And he's being held in contempt for even appealing to the Second District Court of Appeal because they made this overbroad order up, which they never presented any evidence on to begin with. And when I told them those 3 evictions were filed by another third party, not my client, they then dropped the third party. And instead of dropping the relief and getting out of it, they doubled down and tried to look at the thing. Monira Hall's name's not on any of it. So, first of all, Middletown never got an appeal before. Secondly, the case law is, even though the ex parte was affirmed, they limited that to just those 3 pleadings. They did not get into, them having to prove. The case law is pretty clear. I cited it in the brief that you have to prove that hearing. In fact, Judge Lucas, I'm sure everybody is aware, every TRO involving stalking and domestic violence, they enter an ex parte all the time. And you have to have the hearing. And at that hearing, the plaintiff has to prove they're entitled to that relief. They have to prove those 4 elements with confident evidence. That's what didn't happen here. And it is true that I still think I cited the case that my client should have got a chance for cross-examination rebuttal. I found it interesting to find no tenant testified of any kind, anything was wrong. Nobody testified specifically, and my client did anything. In fact, he doesn't. That's the whole irony of this whole thing. He not only didn't file those 3 eviction actions, the only thing he did was become a victim of this ridiculous bankruptcy mess. And it is a mess because the contract, which we filed later to try to show the court, the contract was between the trustee and Rand, INX 7, not my clients. The settlement agreement, which never signed, was between the trustee and my clients, and a stipulation between trustee and my clients. So bottom line is, when Mr. Rand closed on April 7th, he knew that they didn't have title to give him and that the title was messed up. But he wanted to close so bad because it's such a great deal. There was no competitive bids. There was no appraisals. He wasn't even paying the creditors, the secured creditors in full, that he closed it. And this was the last key that he needed in order to now claim he had possession of the properties. And incidentally, since this has happened, there's been no depositions allowed of any of their properties. There's been no production of any discovery of what's happened to properties, what money's been made off the properties or not made off the properties. Not anything like that is available. And my client has been being held for contempt for any defense, even in appeals. If he does an appeal of an order, and now there are now, I think, 7 lawsuits filed by Rand and his various entities, maybe 8 that are pending now. And every time they come forward and say, you can't defend them, look at this order. It says right here, no prosecution or defense. You can't even bring up, you can't argue your defenses or your position or anything else. Then you applied that to Middletown too. So we think we presented ample evidence that there's no irreparable harm. If their remedy is damages, fine. they want to bring a deck action or any other action in the appropriate forum, that's one thing. But to come in here and claim an oral contract, get an injunction on it, and then take the properties and completely change possession of the properties ex parte, then affirm it with no evidence at the hearing, and not even give Mr. Rahal and the witnesses from Middletown a chance to testify, I don't think that's fair and that's right. And I cited the case that said, the court should have given some time. I agree that maybe in retrospect, I would have done a little differently, but at the end of the day, Mr. Rand's situation with this property was extremely complicated. And I think if you read his testimony closely, it was clearly a complaint about him personally, which incidentally, which I found intriguing. Mr. Rand's not even part of this lawsuit. It's this company, INX7, that has no registered agent and no ability to even bring the lawsuit under 605-113, which we never got a chance to present, except that he admitted it's true. He didn't have a registered agent for 9 years. But we're asking for the rules to be followed in this case, and for the drastic leave of injunction to be reversed, especially over all the items that are in the complaint that do not maintain the status quo, and that he has due process of law, and not because you can read their complaint, it doesn't say anything about ownership of properties versus Munir Rahal or the other trusts, or what the situation with those trusts. So the trusts weren't even joining this lawsuit, deliberately not joined.
Mr. Rubai, you are into your 5 minutes.
And thank you.
May it please the court. Oh, thank you. My name is Tracy Carlin, and I represent INXS and all the other plaintiffs below. There's a bunch of them. And we're asking the court to affirm this order denying the motion to dissolve the injunction, because the evidence that was presented at the hearing indicates exactly and by the way, a lot of what you just heard is not in the appendices at all. So it's not part of this case, not part of the record in this case. But we think that, yes, we admit we had the burden of proof to show a prima facie case to support keeping the injunction in place. And I think we did that. Rahal, however, didn't show any change in the circumstances, clear legal error, or a misapprehension of the facts by the trial court, nor did he demonstrate that the facts the trial court relied upon were untrue. And so the big issue here, I guess, is going to be this whole bankruptcy kerfuffle, which at the time that INXS got the properties, excuse me for a minute, they went to the bankruptcy court. There was a sales order that was issued by the bankruptcy court, and everybody on Rahal's side got notice of that sales order, and no one objected to it for well over 18 months. And so at the time that Mr. Rand decided to verbally terminate this oral management agreement between INXS and Mr. Rahal went to the bankruptcy court for the very first time and argued that he should have the properties and he needed to get an injunction. Well, the court said, well, you can't do it through a motion. You have to do it through an adversary proceeding. So those motions and stuff were withdrawn. And then subsequently, Judge McEwen, as Chief Judge Lucas pointed out, Judge McEwen said, hey, everybody got notice. Everybody understood what was going on. Nobody objected for more than a year. We're not going to give him any Rule 60 relief. So that the ownership of the properties is simply not in dispute in this case. And there's no way that Mr. Rahal should be able to collaterally attack a bankruptcy court order in a state court case. And that's why I think the trial court found that we have proven or at least established a prima facie case to support the injunction remaining in place. As far as the irreparable harm is concerned, Mr. Rahal has filed well over 100 lis pendens in 5 different counties. He's also filed a bunch of false construction lien claims and other false claims, which is why I think in the initial phase there was this finding that he should not be able to prosecute or defend these lawsuits because he was taking the position that he owned the property, which is a problem. And that was, let's talk about the status quo for a minute. The status quo was that INXS owned the properties and was a good faith purchaser for value under Section 363M. He terminated Rahal and demanded the return of his property. So the bankruptcy court transcript from September 8th, 2023 establishes that there's no true controversy regarding InXS's ownership of the properties. There was nothing fraudulent. Mr. Rahal was gaslighting the court. And so therefore, there's just simply no dispute about who owns his property. And because of that, we can show that we have a likely success on the merits, because first, we own the property, we're good faith value for purchase, good faith purchaser for value. And Rahal actually purported to manage the properties for a full 18 months before Mr. Rand decided to terminate the contract. And it was only then that he went and asked for relief from the bankruptcy court. But Rahal ignored the termination and started telling tenants that Rand was a scammer, and asking Rahal, and saying that Rahal owned the properties and that the tenants needed to pay him and not InXS. And then when when some of their tenants did start paying InXS, who owns this property, that Mr. Rahal started trying to evict those tenants and give them default letters and take action against them. And then also, since the entry of the injunction, Mr. Rahal hasn't complied at all. You know, he's filing hundreds of lis pendens and claims, and he hasn't complied in one bit. And so I think the trial judge was correct to find that we met the standard for success on the merits. As to the lack of the adequate remedy and irreparable harm, again, those hundreds of lis pendens and false claims is some irreparable harm in the fact that it is clouding the title and it's impacting InXS's ability to sell the property, refinance the property, get the value of the property out of it. And also the issues with the tenants, because he was serving default notices and filing eviction actions. And the tenants were irate. They were so irate that when Mr. Rand hired that second property manager, Mr. Lowry's employees wouldn't even deal with the tenants because they were afraid of them. They were so angry. So he had to deal with them directly. So the kind of irreparable harm to InXS's and Rand's business reputation and standing and lost business opportunities are very much cannot be compensated for with money. InXS has lost the ability to work with certain lenders because of the allegations that Mr. Rahal is spreading all over the state of Florida. And without the injunction, Rahal would be free to continue this harassment campaign and wreak havoc with the tenants. And so none of this can be adequately compensated with money. And I think those are the findings that Judge Alvarez found in her judgment, as well as the public interest issues, which is the life, health, and safety issues that Mr. Lowry discovered at the properties when he went to investigate them, including electrical risks like that could cause fire, injury, and death to people. It also was in the public interest to prevent trespass and tenant harassment and interfere with tenant rights. It's also in the public interest not to have false lis pendens and false construction liens and false claims filed in the court records, in the public records. And also it's in the public interest not to have courts clogged with false eviction claims, false claims of ownership, and other things that are clogging up the court and taking over the court's resources. As to the status quo, I think I talked about that. The other issue that came up is, again, this hour-long hearing. We see that as invited error because the trial court said, hey, how much time do you need? And Mr. Rubai said, we need probably 2 or 3 hours. Court says, I'll give you 2, 1 hour per side. And then Mr. Rahal and Mr. Rubai decided to put Jamie Rand on the stand first. And they talked for 50 minutes, leaving only 10 minutes. And the court repeatedly told Mr. Rubai that you're about to run out of time. And so it was a strategic choice to put Mr. Rand on first and to waste that time there. So I think there's no need to provide any remedy at that point, particularly because at no time during the hearing did Mr. Rubai or Mr. Rahal seek a continuance and seek additional time. That only occurred after the hearing was completed. And in that motion, the trial court denied it, but that motion cannot be reviewed on appeal. It's not a 9.130 authorized appeal. So with respect to the bond amount we think is adequate, and it's been looked at a couple times by a number of different judges. This case has had 5 different judges. And in this case, because there can be because there's no dispute over who owns these properties, and it's in excess and not Mr. Rubai, he never owned the properties. He never had an interest in them. He ran and worked on or managed the properties for the trust entities before the whole settlement agreement stipulation and the sale order, which has never been overturned, never been reversed. So Rahal, and also Rahal only argues the bond was inadequate, but at the evidentiary hearing, he didn't make any attempt to introduce evidence as to what the bond should be. And so basically we think the court reached the right result and it should be affirmed. And unless the court has any additional questions for me, I will just rest on our briefs.
All right, thank you, Ms. Carlin. Mr. Rubai.
First of all, straighten out some facts. I don't own any of the properties. She said Rubai. Number two, the properties have never been in Munir Rahal's name either. They're in the name of 19 trusts that were intentionally not joined in the lawsuit by the plaintiffs. And secondly, at no time is there any evidence that Mr. Rahal ever spoke to any tenant at all about anything, or that anybody else communicated with any tenant. No tenant testified at the hearing, and no person testified as to any interference with any tenancy. Also, what's really important is, although there was a closing held on April 7th, my client was kept secret from him, and an objection was filed asking him to please not close this because of the problems with these documents. And Mr. Rand testified that the properties were not insurable. They canceled the insurance because these are wild deeds, meaning if you look at the chain of the title, they show the trusts owning these properties for 7 years. And suddenly on April 7th, there's a deed from a trustee. But the contract it was closed under was expressly contingent on a settlement taking place, which never took place. And Rand and everyone else knew that they were closing on property that could not be insured, and they were not getting possession of the property. At no time did that status quo ever change. Also, what counsel is leaving out is that my client was trying to follow the bankruptcy court by making the motions in the bankruptcy court the proper way. And what they did is they jumped down to the state court and asked for this relief. And then later the judge said, well, if they want to do it in the state court, I guess it can be in the state court. But they had already gotten an injunction preventing my client from litigating. I don't know what they're talking about when they said they filed those lawsuits. They're talking about the 3 lawsuits that they're saying. There isn't a lawsuit. I'm trying to think of any lawsuit that's pending by Munir Rahal related to these 25 properties at present, and I can't think of any. Okay, so I don't know what they're talking about, because at the end of the day, the trusts of the parties are involved here, and you cannot get a litigation injunction under Logan versus Logan. A bond requires an evidentiary hearing. We waited for 2 years to get this hearing, and we were supposed to get one within 5 days. And we should not have been denied the opportunity to fully address what arguments they had made. And I respectfully disagree that damage like reputation for an individual and his view of how it makes him look is something you can get an injunction over, a prejudgment. This injunction has to do with prohibiting my client from litigating and prohibiting and allowing them to collect all the rents on these properties and ordering him to stay away, which he has done religiously because it's been ordered by the court. But I don't see that there was any basis to ever do that, given the fact that they didn't follow any of the rules to do it, and they didn't present any evidence at the time of the hearing.
All right. There's no further questions.